Okay, it's Philip Lee returning with another episode of Civil War Chat. It's now Friday, the 23rd of October. We're going to talk about two things. One is the experience of the Supreme Court during Reconstruction and how the current situation is kind of an echo of that. And the second is a success story. A Confederate statue has been saved in Chattanooga, Tennessee. So to get started on the Supreme Court, Joe Biden was interviewed by CBS, and he told them that his plan was to appoint a commission. If once he became president, appoint a commission, give the commission 6 months to investigate the legal structure, and then give him a recommendation on court stacking. Since he's been a politician for 50 years, my expectation is that what will happen is that this will just be a rubber stamp, and the Democrats will proceed to stack the Supreme Court. To do that, they'll need Biden's backing. They'll also need to have a majority of the votes in the Senate and a majority of the votes in the House. Yeah, that's a possibility. That could really happen. So here's what happened during Reconstruction that is similar. From 1865 to 1869, Andrew Johnson was president. He became president a month after Lincoln was inaugurated for his second term. So Johnson served almost 4 years, just 1 month short of 4 years. During that 4-year period, there were 3 vacancies in the Supreme Court. When he ascended to the presidency, assumed the presidency upon Lincoln's assassination, there were 10 members of the Supreme Court. 3 of them went vacant during his 4 years. He nominated successors, but the Republican-controlled Congress refused to take any action on those. And so therefore, at the end of his term, there were only 7 justices in the Supreme Court. When Grant was elected president in 1868, then took office in 1869, then the Republicans put in 2 more justices, making for a total of 9. And since then, we've had 9 justices in the Supreme Court. But they did not put any justices in until they had the ability to make the nomination and also pass on them. They didn't want Johnson making the nomination and then passing on anybody that Johnson recommended, because Johnson and the Republican-controlled Congress were at loggerheads opposing one another on Reconstruction plans. What happened during this 4 years of Reconstruction, and some extending into the Grant administration as well, is that Congress, the Republicans basically used their power in Congress to neuter the power of the presidency and increasingly neuter the power of the Supreme Court. It was a frightening 4 years in that context because the Congress was just taking over and the checks and balances were at risk. They came within 1 vote of convicting President Johnson on 11 trumped up charges for impeachment. And now I'll tell you what they did with the Supreme Court. Well, I've already told you some of it, but I'll tell you some more that shows that the Supreme Court power was being negated as well. In 1867, the Republican-controlled Congress passed the Reconstruction Acts that laid the groundwork for the 14th Amendment, which gave voting rights and civil rights to blacks in the South. And the real purpose of the amendment was to be sure that puppet regimes, Republican-controlled puppet regimes, could be set up in the South, thereby keeping Republicans in control in Washington. That's my opinion. I can give you the facts for that, but that'll have to be another show. In 1867, a newspaperman in Mississippi made some critical remarks. There were a number of articles that were critical of the Republicans. The military commander down there put him in jail, presumably for seditious activity. He relied upon one of the acts that the Republicans had passed in '67, along with the Reconstruction Acts, and it's called the 1867 Habeas Corpus Act. Now, they did it because they wanted to help blacks and white Republicans in the South avoid illegal incarceration. Prior to that act, if you were thrown in jail, you could submit a writ of habeas corpus to the state courts, and then the state courts would rule on whether or not you had been legally incarcerated. They didn't want that because they felt that the blacks and the Republicans in the southern states would automatically fail in all their habeas corpus attempts. So the new law, the 1867 Habeas Corpus Act, enabled them to appeal to the federal courts to see if there was any constitutional violations in how they were incarcerated, or whether they were, under what terms they were incarcerated. Well, the Mississippi newspaperman, his name was McCardle, used that act to get released from jail. He wanted to get out of jail. So he used the federal act. He appealed to the Supreme Court for this writ of habeas corpus. The Supreme Court agreed to hear the case. The Republicans in Congress reacted arrogantly, and well, what they did was they passed a new law that said the Supreme Court of the United States had no authority to make any ruling pertaining to the 1867 Reconstruction Acts. That right there is a remarkable thing. But even more remarkable is that even though McCardle had appealed under that act before Congress responded with another act saying that the Supreme Court had no right to rule, that's ex post facto. In other words, they took action after the McCardle made his appeal. That should have no effect on his appeal. And any court today, I think, would say, no, this act that comes later has no effect. But who knows how this will go if you get Biden in and he dies and you've got Kamala Harris in charge. Nonetheless, this went to the Supreme Court, and the Supreme Court ruled that it had no authority to act, even though the act that denied them that authority was passed after McCardle had submitted his appeal. It's remarkable. Congress was becoming a Frankenstein. Among the checks and balances with the other branches were in great peril. The Supreme Court's justices were frightened. That's really the only reason I can see why they caved in on that ex parte McCardle case. Now, just to sort of continue the story a little bit, and McCardle is settled in a way that really is quite frightening. But the 14th Amendment also had some interesting aspects. A lot of historians today say, well, it was set up to provide civil rights and voting rights to the blacks. Well, it was really set up to make the Republicans have control in the South. If you look at the 14th Amendment and the cases that were brought before the federal courts involving the 14th Amendment during the 19th century, say, it was passed in 1868, go to 1900. In that 32-year period, the overwhelming majority of cases involving the 14th Amendment involved petitions by, quote, persons for relief, but these, quote, persons were corporations. The courts had ruled that a black ex-slave was a person. And they also ruled that a corporation was a legal person in the context of the 14th Amendment. So the corporations used the 14th Amendment as a legal protection against encroachment on their rights, so-called rights, encroachment on their rights by the states. And the biggest example was a number of the states wanted to regulate railroad rates because it was essentially a monopoly. And they used the 14th Amendment to say, no, you're a state. Our rights are protected under the 14th Amendment. You don't have a supremacy here. In one case involving the Southern Pacific Railroad in California, their lawyer that represented them was Roscoe Conkling, who claimed that was present during the draft during the drafting of the 14th Amendment, and that it was carefully worded to ensure that not only were persons like ex-slaves protected by the amendment, but also persons like corporations. That may be true, but it's doubtful. Nonetheless, that's his claim. It wasn't just him that claimed that, other Republicans claimed that. John Reagan, who was Postmaster General of the Confederacy, went into Congress during Grant's administration, and he wanted laws passed by Congress and signed by the president that would empower shippers to sue in federal court the railroads for price gouging. But what came out of it instead was the Interstate Commerce Commission, which was the first of the federal agencies that Congress essentially turned power over to. And it was the beginning, in that context, of a deep state of agencies like the Environmental Protection Agency and all this, where decisions are made affecting people that, and the decision makers haven't been elected by anybody. But initially, the Interstate Commerce Commission really didn't have the power to even set rates. It could conduct investigations and say, okay, the Southern Pacific is overcharging on its rates between San Francisco and Los Angeles. Then it had no further power. Somebody could then go to Congress and say, look, here's some facts, and let's get together enough congressmen and senators to vote for a bill enabling us to sue on this, and then they'll have the president sign it and all that. It was really kind of a hopeless thing. It was a agency that became more of a lapdog than a watchdog, which is kind of typical of all these agencies. But that's just a little bit of an extension of the interpretations and ramifications, shall we say, or implications of the 14th Amendment beyond what we're told by academic historians was the real purpose of it. Bottom line, if it was really set up to protect the blacks, why were the great majority of the cases before 1900 that were brought relying upon that law, relying upon that amendment by corporations as opposed to human persons, black human persons particularly? But anyway, that's what happened. Now let's look at Chattanooga. General A.P. Stewart has a statue there in Chattanooga, and there's some sort of a commission involving 9 people that voted recently 6-3 to keep the statue. I got an email from somebody that had seen a 6-minute video I had done for the Abbeville Institute in defense of Confederate memorials, not anything specific about A.P. Stewart, but in defense of Confederate memorials. Since it's only 6 minutes, it's something that that packs a lot of information into a short amount of time. And the attention span apparently was good enough for 4 of the 9 commissioners. The guy who wrote the email to me said claimed they had watched it and were influenced by it. He said after the favorable vote of 6-3 to keep the statue there, he was told by the head commissioner that the video was instrumental in his decision to support the statue. So what I'm going to do is I'm going to put a link down below here on this YouTube video to that 6-minute video. And if you like it, please watch it. If you like it, feel free to share it, because I think the reason I'm switching from my Civil War chat blog to these videos is because I want to have more impact. I want to have more impact on what's going on with the Confederate memorials. The mob destruction that we've seen since June I've had enough of it. I've got to do something different to try and turn that thing around. And then lastly, let me conclude with this, that if you want to defend Confederate memorials, this book, which I just put out, and it was just published last month, The Causes of the Civil War by Philip K. Leigh, Leigh. You can get it for $22 at Amazon. If you want a personal copy, I can, personal signed copy, you can contact me, Phil underscore Leigh, Leigh, at me.com. $25, and I'll cover the shipping if you're here in the United States. I'll sell you a signed copy. This is important because it's going to provide you with the explanations and facts you need to defend Confederate monuments. It's to an important extent, it motivated, the writing of this is motivated, was finally triggered by the mob destruction on the statues that I saw. I had been working on this for months prior to that, but it really, my work intensified and accelerated once I saw what the mobsters were up to. So I'm really trying to, with the videos, get to, help save the memorials. I appreciate everything that you do. One of the things that you can do is buy this book, get the facts that you need. If you're going to go before a commission to try and turn things around, get the facts here, get the explanations you'll need. Civil War Causes of the Civil War by Philip Leigh. Okay. Those of you that have been watching me in recent days know I'm just switching microphones. Let me know if you think that this is an improvement. If not, I'll keep working on trying to get one that is better. Okay, for Philip Leigh and Civil War Chat, that's our show. Thanks for watching.